I'll be on top again. I'm not gonna let you take me down. It's gonna be the whole nine of yards or nothing.
Welcome to Legal Straight Talk. I'm Brett Harrison, attorney with the Harrison Law Group. Today we have a great show. I'm happy to bring in a criminal attorney, always a juicy area, Thomas Lavalle, a former, and I'm going to say this, former DA from Suffolk County. So he knows the ins and outs of what really happens in the criminal courts. Thank you for coming today.
Brett, I appreciate you inviting me here today.
Okay,
I'm going to
give you the ground rules.
Okay.
We try to take the legalese out of the legal, and we try to make it common sense so the common person that's not practicing law doesn't get confused when they hear all these different terms that we hear in the criminal court, and they go to the courtroom and they hear all these terms and they have no idea what's happening, and then they say, what happened? Which often happens.
Make it simple.
Making it simple.
I think I can do that.
All right, good enough, fair enough. We're going to start with an interesting topic. I think I want to talk a little bit about D.W.I. because it's such a big topic from MAD, SAD, all these good groups, and you just read about it in the papers. You see about it all the time on whether it's Channel 12, whether it's Vios 1.
Just look at Newsday.
Newsday, it's always the first couple of pages.
On Newsday, there was an article about somebody who's alleged to have been drinking and driving. So that's why I always tell my clients when they come in, this is the political, hot, area now in the criminal law, especially for the prosecutors,
And it happens, for example, tends to happen a lot more on Long Island because people have to drive. They can't rely on the bus system.
Exactly. Everybody has to drive, and like I said, in Newsday, you always read about somebody driving the wrong way, someone getting into very serious accidents, and it is very serious charges.
But one thing I think people should realize, and I think we should make sure people understand this, it's not illegal to drink and drive. Am I right?
That's what I always say to the jury. When I pick a jury, I always say, I ask, is anyone in this jury that doesn't drink?
Well, you might get a couple of people.
Oh, you do?
And you got to get those people off your jury.
Absolutely.
Because that's not a jury of your peers.
At least that's what you try. But if they don't, Although I've picked people on juries that, just because they don't drink doesn't necessarily mean they can't be fair. But I always talk about that, and I always talk about the fact that it's not illegal to drink and drive, right? Everybody goes out to a bar, goes to a wedding, maybe has a couple of drinks. That's okay. But you can't get to that point where you're impaired or intoxicated.
But that's a difficult thing because, most people think of, how Dean Martin in his skits used to show he was falling off his chair and he could barely find the keys to his car. That's obviously that person's drunk. He or she can't drive. But it's not everybody. To be impaired, you don't have to get to that level. Am I right?
Absolutely not. Actually, I took the breathalyzer once. They did a little test where they brought the officer in, but I did have quite a number of drinks. I had 6 Heinekens in 1 hour, and I blew a 1-up.
But you must have had some food in you.
I did have a little food, but like you said, a couple of drinks, a couple of beers can get you up at least into that impaired area.
And people also have to realize whether you have 1 beer, 2 beers, or 1 shot, or a vodka drink, or a glass of wine, they all can end up equaling roughly the same.
Exactly. That's what I always try to say. Say 1 beer, 1 glass of wine, 1 shot. That's all the same, like you said. And the general rule that the lawyers use is that's a .02. So if you have 1 beer, that's a .02. And for every hour that goes by, your body expels a .02. That's kind of like a general guidelines.
But then it also depends, I guess, if you how much you ate and so forth, if you've had food in your body, how long from when you first drank, like you said, to when you took a breathalyzer. But we'll get into all of that. Now, one thing I think people should understand is, and I think there's a big confusion when I just have general talks, and you've represented a lot of clients, and they say, how can you represent, they always say what? Guilty people. Let's understand, and I think you should define for people, what actually is the role of a criminal defense attorney?
Well, to zealously represent your client. to get, well, I always say, what's a fair resolution of the matter.
Well, before we even get that, let's discuss the difference role between a district attorney who prosecutes criminal cases has a very, very different role than a criminal defense attorney.
That's true, but you know what? As you know, a prosecutor does have a duty to seek justice and not just prosecute somebody because they may be guilty.
Right, it's the people of the state of New York, whatever county, verse. So they also have to look at the justice, exactly. Your job as a criminal defense attorney is a little different. That's different than zealously sometimes. Your client could be what they tell you in confidence, okay? Because, A, the people have to prove the case, correct?
Right, so exactly like you said, your client could actually be guilty, but
But
you could have the case dismissed.
Because there's a lot of reasons, and don't hold it against the criminal defense attorney. He wasn't the one that chose to prosecute. As you said,
That's my job.
That's your job, is to prosecute and to make sure the I's are dotted and the T's are crossed. But more importantly, the burden of proof. Explain what the burden of proof is to the DA and how that fits into this whole equation.
Well, everybody's always heard of proof beyond a reasonable doubt. That's a burden of proof if you go to trial. But obviously, 90-something% of the cases are resolved before trial.
Thank God they are. Can you imagine
The courts couldn't keep up.
Right, but that's an important thing to understand, a burden of proof. Who has that burden of proof? Which actually means you could actually sit there, not have your client testify, not even say a word.
You sound like how I speak when I pick a jury.
Oh, well,
I
I'm
can
not
sit
trying
there and
to-
not even ask a question
That's right.
because I don't have the burden of proof.
Because as your client sits there, they are presumed innocent, and that's not something to be taken lightly.
Absolutely not. I always say, and I hate to keep going back to that, but that's what I say when I talk to a jury. You're presumed innocent, as innocent as anyone that's sitting in the box. If you believe in the Constitution and you believe in the law, you're presumed innocent. The prosecution has the burden, and they have to prove it beyond a reasonable doubt.
You have a right, and when you're charged, to put the people to the proof, to make sure that they can prove that you're guilty. You do not have to prove a burden of, I am innocent.
Exactly.
And I think people misunderstand that because a lot of times when they're sitting there in the jury, they say, well, I don't know if the person's guilty or innocent. I kind of have to hear what each of them has to say, and then I'll make my decision. But that's not accurate, is it?
It's not. It comes down to, do you believe the people's version beyond a reasonable doubt without even, like you said, the defendant or the defense presenting any evidence or witnesses?
How would you describe that concept of beyond a reasonable doubt? What does that mean?
Well,
Does that mean I'm not sure, 50-50? If I can't say they fully believed it, if I'm not sure, they haven't proved it beyond a reasonable doubt.
if you want me to describe it,
How would you describe it? If I'm sitting here and you're picking a jury, okay, how would you tell me, you'd ask me, juror number one, how would you do it?
well, kind of almost like some of the jury instructions say, it has to be so convincing that you don't have any reason to doubt.
But a
The
reasonable doubt, it can't be some pie in the sky.
Right, you can't like they say, it can't be based upon speculation. It's got to be
So saying I'm not sure who to believe, that's a reasonable doubt.
exactly.
So it's
Because of a case of this importance, you know what I mean? It's not, like you said, it's not maybe the person's guilty. It's not more than likely the person's guilty. It's proof beyond a reasonable
which is
doubt.
different, so people should understand, it's different than a civil standard, which is preponderance of the evidence.
That's your area.
Well, that's one of them, but yeah, that is predominantly my area, which is very different than beyond a reasonable doubt. And I think people should understand, it shouldn't be taken lightly, because you're dealing with not just their freedom or whether they're going to be in jail or not, but you can affect, and correct me if I'm wrong, this could have dire civil consequences.
Absolutely.
Can you explain to people what when we say the civil consequences in plain English, give examples of what, when you're, as an attorney, when you're interviewing people, you want to understand what they do for a living and why that's important.
Well, if you want to talk in the realm of DWIs.
Yeah, let's talk DWIs. We'll stay with DWI for now.
Well, and when you say civil consequences, you're talking about maybe like licensing issues?
These are civil consequences. Have nothing to do with jail. but it has everything to do with surviving. Let's say I'm a teacher, I'm a police officer, or better yet, I'm an accountant, I'm an attorney, something that's licensed by the state. That
Right,
can
then
be-
you always have to worry about the person's, like you just said, the license issues. Will that conviction cause them, to lose or maybe have their license suspended? But what I think about with DWIs is the commercial drivers.
Oh.
Because you can have an individual who's operating his passenger vehicle, right, just going from a party or wherever it may be, and he or she gets charged with a DWI.
Yeah, they're not driving. They're not driving their big rig.
Right.
But people understand, on their license, what class would they be? Whether you drive your personal car, but if you drive a commercial vehicle for a living, you have what type of license?
You have like a CDL license.
A CDL license, which follows you if you're driving your personal car on a Saturday.
And the problem with those
So
type of
let's
cases,
say I get pulled over,
right.
and I have a commercial license, but I'm driving my Hyundai. I'm not nothing to do with,
Let's even make it better. You are the sole supporter of your family, and that's what you do for a living. You drive a truck. Well, any type of disposition in the criminal matter, whether it's driving while intoxicated or driving while impaired or reduced charge, you are going to lose your commercial driver's license for 1 year.
Can I conditionally drive?
No.
So you're saying that there's no you're gone for a year.
Yep.
Now, let's be realistic. What are the effects of that besides, okay, now if you're the sole supporter of your house, now you can't work. There's no conditional license.
Exactly.
So on top of that, though, the reality is, if you have a CDL, what company is going to hire a risk of someone that has a prior DWI? Because don't they do a background check?
Absolutely. And like you just said, whether it's, when someone's arrested, most people get arrested for driving while intoxicated, right, which is the misdemeanor crime. And most times when you're representing somebody, you try to get it reduced to driving while impaired,
Well,
which
let's
is not a
explain the
crime.
difference
Okay.
between intox on the breathalyzer readings and explain what a breathalyzer is.
Okay. Well, if you're stopped by the police and you, at the precinct, blow into an instrument, let's say the intoxilizer, they're up
Hold
to
on.
like the night.
So you're saying then, what about when you get stopped on the road and they ask you to breathe into, the cop pulls out an instrument, he says, hey buddy, breathe into this. Is that what you're talking about for people?
No, but maybe I'll even start at that point.
Let's start at right.
You get stopped by the police. They tell you to come out of the car. We've all seen it. They tell you to do all these various.
That's when they
tests.
have the lights on and everybody slows down when they're passing to see who is it, who's stopping, and it
Exactly.
causes a traffic jam.
That's
and people
exactly
are
it.
so nervous they can't even remember their name.
Yeah, that's when the officer's asking your client to perform tests. So they'll do what's called the horizontal gaze nystagmus test, right? The pen test, we call it.
So do it to me. Show me what that is.
Well, I'm not a pro, but they would take a stimulus, and usually it's a pen, and they'll hold it 12 to 15
Right.
inches in front of your face, but it's also got to be slightly above
Right.
eye level, and then they will conduct tests moving it to the right and
But this
left.
is while it's night out and the turret lights are the lights that go around, right? And then this car is passing, and
That's true.
and I'm supposed to follow this. Besides going in my pants that the cop stopped me and I'm outside and I'm thinking, if I answer wrong or I even get more nervous, I'm going to be arrested with the indicia that I'm drunk.
Correct. And these are all subjective tests. So we've seen that.
But
then
he's trained. He or she is trained.
Right. That officer is trained by other police officers on how to administer that test. See, those are kind of questions I ask at a trial. Do
Oh.
doctors teach you this? Do nurses instruct? Other officers.
But the real thing is, and I think people should understand, is I get stopped. I get told to pull over. Now, I don't even know, let's say I'm on a hilly thing. On a hilly,
Right.
because a lot of times they ask you to stand on one leg for what, 20, 30 seconds, 5 seconds, how long?
30 seconds.
I don't even know if I can do that straight.
Well, sometimes jurors will do that in the back and say, wait, I can't even do it normally.
Especially, now you could be on an angle, right, on a
Exactly.
hill. You have all these things passing you. That's like being called up in the middle of a restaurant, told, you know what, give me a speech. Let me see if
Well,
you're nervous.
It's even better than that, right? I mean, the officer barks out orders to your client on the side of the road. Put your hands at your side. Keep your foot.
It's
in
not
front of the
Simon-
other-
it's like
and
Simon
And they're
says.
just bombarding you with instructions. But They're not telling you how they're going to grade you. They're not telling you how they're going to test you. And then when you perform the test, they don't even tell you how you did. And they don't tell you things like, do your heel to toe, but you can miss, but it can't be more than 2 inches. They don't tell you you can raise your arms, but it's got to be less than 6 inches. They just bark out orders. So it's kind of like an unfair type of test. They're telling you instructions, but they're not telling you how they're going to grade you, and they say, go ahead, go do that. And you're at the side of the road, and you're nervous, and you've never been in this circumstance, and all those things you just talked about.
Well, but you know what scares me now? So now they're making a decision based on how I do on these tests with all the lights. It could be raining out, could be wind, okay? There's so many things.
Yeah, you're not going to get the benefit of the doubt, trust me.
But you know what? This is interesting to me because, what was it? I think it was Andy Warhol said, there's certain things you have to experience, you can't just hear. One of them was sex and parties. Well, it's like the same principle to me. Unless you've experienced it, a juror sitting in the back listening assumes, well, no, that seems like normal, but they can't put themselves in that situation. And anybody that's been in that, are they going to be thrown off the jury?
Sometimes yes, sometimes no.
Would a
Depends.
DA ever let them stay on the jury?
I've had them leave jurors like that on the jury, yes.
Not usually, though, I would.
Not usually.
'Cause
No,
they
but
understand-
said, well, because
'Cause they
in my
understand
particular, they said other things that the ADA liked. but
So now, when they're doing these tests, they're making a decision whether they have, I think.
probable cause,
Is there-
reasonable cause.
Reasonable cause to detain you, detain you meaning you can't go anywhere, your freedom's stopped right now. You can't just walk away. Is that what that means?
Well,
In layman's
initially
terms?
they have, right. Well, it's different levels. I don't want to get, like you said, let's kind of keep this nice
No,
and
but
simple.
if they feel that there's a reasonable cause to detain you further, you're not free to leave.
Correct.
You can't say-
Reasonable suspicion. We'll
Reason,
use-
and that's based upon their training and these
right,
crazy
you
tests.
smelled of alcohol. You were erratic in driving.
Which reminds me, a lot of times, pretty much, you could die. You can write out a drunk on there. They have what's known as paperwork that they have to fill out. Is that
Correct.
correct? And a lot of the questions they ask, because they want it to be standard, did they slur? Did they have an odor of alcohol? Is that right? There's a whole bunch of questions where honestly, you could check a drunk.
Every D.W.I. case I have, when I read the accusatory instrument,
The same questions, right?
it's all the same.
What does vodka smell like?
Alcohol in breaths, bloodshot, glassy eyes, slurred speech,
Well, okay.
unsteady gait.
Is
it's all the same.
it unreasonable that if you woke up at 8 o'clock and now it's 2 o'clock, your eyes are going to be red because you've been up for God only 18 hours, 20 hours?
Exactly. Well, those are the issues that you bring out of the trial.
Or when somebody's
But-
asking you a million questions and the light's going out, you're not that you're. How does he know if you're stuttering the officer if they don't know you?
Exactly. No, all these things those are the issues at a trial that you talk about. But as we were talking about, right, you do the horizontal gaze, the pen test.
Right.
Then they do the walk and turn test. Then they do the one leg stand test. And then usually after that, they do the pre-screening breath test, which we started to talk about.
So that's it. What's the purpose of that then? If they
Well-
can't use it, or can they use it for reasonable cause?
They can't, right. They can't use the pre-screening breath test that's taken at the side of the road as evidence at the trial. In other words, you went to trial, the jury would not learn about that because it's not scientifically reliable. But it can be used as a basis for the officer's probable cause to believe that the person's intoxicated.
To
So
keep you further detained and take a breath test or something.
at the precinct. So there's, normal procedures like we just talked about. You do all these tests, then they do the pre-screening breath test, then they arrest the individual.
Okay.
And now they're brought down to the precinct and they're asked whether or not you want to submit to a test. And that's always the big question that I get asked. Should I take the test? Should I have taken the
Well,
test?
let's go back. Let's back before we even get to that, which makes me. I was going to ask that, but so you're stopped. Okay. Now,
What would I do?
no. Well, exactly. Now, sometimes they say.
If I was drunk,
Well, if
I
they-
would do nothing.
if
I
they-
would not do any tests.
If they
I would
ask
not
you,
answer any
but
questions.
the first question they ask you is, "Sir or
Have you
ma'am,
been drinking?"
Have you been drinking?" Now, that's a tough question. If you say yes, right, they're going to say, "Well, how many?" Is that the next question? Or when?
Most officers, yes.
Or will they say, "Please step out of the car as soon as you say yes"?
It depends. Every officer obviously
Depends if
is
you're in a
different.
village If you're in a village,
Listen, no matter what, once you say, even if you don't say yes,
But
but
if-
you're
but
going
if
to
you
be
s-
asked to step out of the car.
but if you say yes, aren't you
coming out of the
doing?
car.
You're coming out of the car, correct?
You better believe it.
Okay, or even on a checkpoint, let's say you're not pulled over for crossing the W.I line, not signaling.
Mm-hmm.
Clearly, you must be in Long Island if you didn't signal and you get pulled over, because
Right.
they don't do that in the city. But okay, and the purpose of that, when they do note that, is why? Why do they have to say, oh, well, they didn't signal or they didn't fully stop? What's the purpose of that?
Why do they offer? Well, there's two reasons. One, you need what? A basis to stop the person, right?
So that's their basis to stop.
Yeah, it's usually it's
Or is it
generally
because
it's failure to maintain the lane. That's 1128A. That's
Does
the
that
section
usually
they
mean
always
it's past 12 o'clock, it's 2 in the morning in Long Island?
Yeah, coming out of Patchogue.
Right, exactly. Or you're coming out of a bar, so there's an assumption.
Somehow
Or
they just happen to be sitting.
They
across
happen
from
to
the
wait
bar.
there because it's a good place to wait.
Exactly.
So it's not that they're looking for it, not that they're assuming.
Well, like we said, that ticket's the basis for the stop, and it's also put in there because, driving while intoxicated is how you operate the vehicle, right? Like we talked
Right.
about. It's got to affect your ability to operate the
Impair
vehicle.
your ability.
So that's why that's
So
also
now let's
there.
get back to the first question, which was, so they stop you and say, Mr. Lavalle, license, registration, have you been drinking tonight? How do you answer that?
No.
So even if you say yes, and then if you say yes, how many did you have? You may say 1, right? Or 2.
Well, everybody always says 2 or 3.
Right.
That's
And-
the general answer.
And if they believed you, they probably wouldn't stop you further. So no matter what you say, they're not going to believe you. Is that a fair statement?
I would agree
That
with
is
that.
generally,
Yeah,
um,
absolutely.
But I want to make sure one thing is clear, though, to the audience. Tom and I aren't saying that DWI laws are bad. Matter of fact, he'll be the first because he's represented hundreds, if not thousands, and he's prosecuted hundreds, if not thousands of people. It is a good law. Let's be perfectly clear. We're not saying the law is bad in any matter. It saves lives, it protects lives, and let's hope it prevents accidents and so forth. And I'm sure you'd agree with me.
Absolutely.
This isn't what this is about. This is about whether they violated the law. Okay, so this is clearly good law, and organizations, as Mad said and all them, there's an absolute need, it brings attention. So I want to get that out right from the get-go.
I'm 100% with you on that.
Okay, but now moving past that, so now you go down to they take you down to the precinct because you either failed the test or they have some, as you called it, reasonable doubt, a reasonable belief that you have been drinking and it's impaired your ability, be it failure to signal, failure to fully stop, excessive speeding, whatever it may be.
Okay.
Plus, they also, maybe you agreed that you've had a drink or two. Now they say, well, Mr. Lavalle, you know.
You're going to take
what-
this machine? You want to blow into this machine?
Now, people need to understand, driving is not a right, it's a privilege.
Exactly.
And what that means, well, how does that, when you say it's a privilege, what does that mean with regards to whether you have to take that as part of, do you have to take that breathalyzer as part of that privilege to drive?
Well, why don't we start with the first
Okay.
avenue? Let's suppose the individual wants to take the test.
Well, okay,
wanna
would you
start with that?
recommend it?
I would say if you know that you are highly intoxicated,
Well, when you say that, let's backtrack. If you know, so you're saying if you had a drink or 2 drinks, maybe even 3, but over a number of hours,
take the test.
if you had 26 bottles of beer on the wall and 10 shots, obviously you shouldn't be driving anyway, and you're going to fail anyway.
Exactly.
Miserably.
Let's say this. If you've had, because I'm just thinking about the experience I said when I told you I took the test once. If you had more than, let's say, 6, 7,
Over what
8.
period of time? And
Well,
what
that's
did
true,
you-
but most people are going to go out for a few hours. You might not want to take that test
Well, let's
because
say-
they have guidelines in the DA's office. If you blow a .13 or more in that machine at the precinct, their general rule is going to be no plea bargaining. You have to take a plea, you have to go on probation, you have a criminal record, you have to
Well,
put
okay, if
ignition
you plead,
interlock
if
in the
you,
car.
and DWI in New York is, what's the BAC reading?
.08 or above.
Well, okay, and impaired is what?
0.05 to 0.07.
Okay, but now there's also what isn't there aggravated DWI now?
Correct.
Which is
0.18 or more.
what's the difference between that's like saying I'm halfway in the grave and now I'm all the way in the grave.
Well,
Bad to worse, but what's the difference?
The difference between what I'll call a regular driving while intoxicated and aggravated is just really the penalties. I mean, they're both crimes. They both, if you plead guilty to them, you're going to be put on probation. They're both going to require ignition and interlock in the car. The only difference is the fines are a little bit more, and the revocation period is going to be extended. That's really the difference. But it's still going to get you a criminal record, still going to put you on probation, still going to put ignition and interlock in the car. So that's...
And impaired, does that give you a criminal record?
No. Driving while impaired is as I always tell my clients, it's a traffic infraction. But it does, I always say it has serious
Affects your
implications,
insurance.
your insurance, your license, but it's not a crime. So that's usually the goal when you have a client that has a driving while intoxicated charge, never been arrested before, no accident, no aggravating factors. You try to get that reduced so they don't have a criminal record and they don't have all these other burdens like we talked about, the ignition, interlock, and
But that
probation.
totally changes if they have a CDL or commercial driver's license. Then your world and the way you're approaching it probably
And
changes.
now you have to win the whole case. So that's, makes it a lot more difficult.
Well, we even just touched on only a little bit of it because I guess I got off on tangents about different aspects of it, but
That's just us talking.
yeah,
So-
well, because it's talking shop essentially and just trying to put some sense into it, some of the reality of it, and using your experience as both the DA, who's prosecuted, knows behind the scenes, as well as the behind the scenes from a criminal defense attorney. What we're going to do is we're going to have a part 2
Great.
at another time, but I want to thank you for coming. You can. It's Thomas Lavalle, and we're talking about drunk driving, and we'll talk about other criminal aspects. But I think I want to talk a little bit more next time regarding the courtroom part of it, and still at the precinct.
Okay.
All right.
About taking that test.
Taking
or not.
that
We
test.
just started getting on it.
We're going to talk about that, and which counties, why it makes a difference which county. Once again, thank you for coming in.
I appreciate it.
And we'll get back to business again on this show.
I'll
grill you some more.
You got it. I'll see you shortly.
Okay.
Give my regards to Broadway. Remember me to Herald Square.
Hi, I'm Jerry Parisi. Join Tom Mealy and Tommy Marr right here on Cablevision Channel 20 each week for an interesting episode of The Long Island View.